Hi everyone, I'm Madelena Viksne from Samfiru, Tumarkin. I am an employment lawyer and I'm here to answer some questions that you might have today. Um, Based on the HBC closure that is happening right now, I thought that I would start off with talking about what happens if a business closes. Employees are owed severance in the event of a business closure, as long as the company doesn't go into bankruptcy or receivership. So, as long as that is not the case, you would still be entitled to your regular severance or termination pay under at least the ESA, potentially more underneath your contract. Um, Severance pay is based on your individual circumstances, obviously. So your age, your length of service, your ability to find new employment, as well as your um, position at the previous company. So all of those factors come into play when you're talking about common law severance entitlements. Under the Employment Standards Act, you are only entitled to 1 week per year up to 8 weeks of notice, and 1 week per year up to 26 weeks of severance if your employer has a payroll of over 2.5 million and you have worked for them for more than 5 years. So all of these different factors come into play in terms of what your entitlements are upon termination. And the factors I just mentioned, of course, are also dependent on your contract of employment. Um, but if your employer is closing down for some reason, if there is the possibility that they will close down, it's important to have a copy of your employment contract, as well as thinking about sort of the factors that I just considered, just mentioned, which would include your age, your length of service, your position, and your ability to find new work. So, what that means is not necessarily your ability to find a position that's exactly the same, but one that is comparable, meaning that you could use your transferable skills that you've learned from your previous position and bring them into a new role. Mark from YouTube asked, can my employer update the employment contracts for all employees without needing approval if it is done company wide? In order for a contract to be enforceable, it requires that you would have uh, consideration. So a contract is offer, acceptance, consideration. So the contract is the offer. Your acceptance is you signing it, and consideration means you're getting something out of signing it, essentially. So, unless your employer is providing you with some sort of change in your compensation or some sort of bonus, so sometimes they will do like $100 in order for you to sign the contract. Sometimes they'll do things like a nominal raise. Um, Sometimes they'll change some component of your compensation within the contract where you will be making more money. Unless you're receiving something in exchange for your signature, the contract won't be valid whether or not you sign it. So that's something to certainly consider. If your employer is now asking you after some period of time to sign a contract, I would certainly recommend that you speak to an employment lawyer in order to ensure that you understand exactly what it is you're signing and what exactly those rights are that you are potentially restricting in respect to the new agreement. Car from YouTube says, I was placed on unpaid leave since November 2021 until February 14th, 2022, but my employer never contacted me yet. I sent an email a week ago, but I still haven't heard from them. Would this be a termination? So there's a number of different factors that you would want to consider with respect to that question. First of all, have you ever been placed on a leave before? What are the terms of your contract or agreement that you've signed with the company? Does it allow them to put you on an unpaid leave of absence for any reason? potentially could be for a specific reason or otherwise. Um, if they haven't responded to you, then, that's something to consider as well. And it's certainly something that we would consider in evaluating the case. If you are placed on an unpaid leave of absence without any contractual right to do so, then your employer has likely constructively terminated your employment. And if that's the case, then you will, potentially have a case against them legally for a constructive termination. So it really depends on it's quite fact specific. So what I would say is you should contact somebody from our office and have them review sort of your contract, what the agreement is that you signed initially, and whether or not there's any correspondence from your employer during this period between November 2021 and February 14th, 2022. It's important to, retain all of that correspondence so that we can review it and evaluate your case specifically. But as I said, it does depend on the terms of your contract and whether or not you signed off on anything and a number of different factors as well. Dan from YouTube said, can safety coordinator be fired for reporting a no loss incident while employed less than 90 days? So again, it's going to depend on your contract, but most of the time, and under the ESA, assuming that you are a provincial employee, there is a probationary period of 90 days permissible by the ESA, and that probationary period, excuse me, means that you can be terminated within the first 90 days without any notice or pay in lieu of notice, and certainly without any severance, because severance requires that you are employed for more than 5 years. So I don't really know that the position of safety coordinator necessarily makes a difference. It will, again, depend on your contract. But most of the time, there is a probationary period of 90 days during which you can be terminated without any notice or pay in lieu of notice. A question from Denise on Facebook. Can my employer terminate my position while I'm on medical leave? I'm on STD and was given notice that my position is being phased out. Again, this is a fact-specific question. If you are on a disability leave, you cannot be terminated for any reason relating to your disability. If you are terminated for a valid, if you're terminated for a valid, excuse me, 1 second. If you are terminated for a valid restructuring of the business, then, your employer has an obligation to accommodate you to the point of undue hardship. Undue hardship is a pretty high threshold to meet, and most employers cannot meet it. And what that means is they would have to explore every other option within the company that they could bring you back to without having to take the step of terminating your employment. You should not be terminated while you're on a disability leave, but it does happen. Undue hardship requires that they explore every option available. If there are no options available, it is possible that they could make the argument that they are, validly unable to bring you back. It's hard to say given that I don't know how large your company is or what your role is or anything like that. But generally speaking, they cannot terminate you while you're on a disability leave because that would amount to discrimination on the basis of disability. Gosia from Facebook says, I've been placed on leave of absence since February 1st. Didn't hear anything yet. What's my option? Thank you. It depends on what kind of a leave of absence you've been placed on, as well as what the terms of your contract are. If your contract, allows them to put you on a leave of absence for some reason or a layoff, then you are going to potentially face challenges with respect to challenging the layoff itself. If there is no term in your contract that allows your employer to lay you off, then you will potentially be able to allege a constructive dismissal on the basis of an illegal layoff. It really does depend on your contract, and it depends on the circumstances that are specific to your case. So it's difficult for me to answer here. Any other questions? Okay, so Belinda from YouTube says, my employer is claiming I have made mistakes in my job that are untrue. How do I claim a wrongful dismissal? So this is a bit of a misunderstanding. You're not actually claiming a wrongful dismissal unless you've actually been terminated and you have not been provided with the appropriate pay or pay in lieu of notice. Sorry, notice or pay in lieu of notice. Um, in this, like based on your comment, it's hard for me to say whether or not you've actually been terminated or whether you maybe were put on a performance improvement plan. It says you've made mistakes at your job. They're untrue. Have you challenged that employment performance improvement plan? Have you signed off on anything? Have they put in place any sort of, training or retraining in order to, remedy the alleged errors that they're saying that you made? Or did you actually get terminated in the event of these allegations? It's hard for me to say based on your comments. So if you'd like to provide more information, please go ahead. Johnsonville Brat says, worked at Fly In Gold Mine, no union. Due to the feds, no fly mandate, can no longer get to work without the vaccination. So this kind of, I think, would involve the third party issue. So there's an issue with respect to the vaccine mandates where if it's a third party who's mandating, your original employer is not actually the one who's necessarily mandating the vaccine. So if the mine itself is not the one who's mandating the vaccine, but because there's a third party that you're working for example, if you worked for a school board and in that school board, they require vaccination, but you're like a cleaner or something like that. In order for you to access these buildings, you would require vaccination, but it's not actually your own employer who is imposing the vaccine mandate. It makes it a little bit more difficult. I think that it would probably be best, Johnsonville Brat from YouTube, if you contacted our office and spoke to one of our lawyers there so that they can kind of get a bit more of a nuanced idea of what it is that you're dealing with. Belinda sort of provided a bit more information. I was given one warning, which I disagreed with, but I was told I'm likely going to be terminated because they don't think it was anyone else who did it. Belinda, I think it sounds to me like whatever it is that you're dealing with is quite fact specific. So again, as I did with Johnsonville, I think that it would be best if you contacted our office and spoke to one of our lawyers personally. It may be too much information to exchange via this forum. And I think that based on what you're saying, it may be worthwhile for you to speak to a lawyer and sort of see what it is. If you were told you're likely going to be terminated in writing, then that would be a written warning that you received. But there are a number of steps within the progressive discipline sort of forum that that should be taken ahead of termination. So what exactly your warning said and whether or not you signed off on it and what exactly the incident is that you are saying you think somebody else did it, they think that you did it. Whatever the specific details of that are, it may be best to speak to a lawyer. The Dreamer from YouTube says, can an employee be on probation automatically without a contract, or does it need to be a consensus? Under the Employment Standards Act, if you're in Ontario, for the first 90 days or 3 months, you are automatically on with a probation, so to speak, whether or not a contract says that. The Employment Standards Act allows your employer to terminate you without notice or pay in lieu of notice during that period of time. If you don't have any written contract, though, there may be other opportunities for you to obtain some kind of compensation. So it may be worthwhile for you to speak to one of the lawyers at our firm. Randolph from YouTube says, I currently work 2 positions to make ends meet, but I'm going to be let go from one due to restructuring. Am I entitled to severance since I have a second job? Good question. So mitigation income involves earnings that you obtain during the notice period that is applied to you. Your notice period, as I said at the beginning, is, figured out by way of cases that have come before it, but it involves factors such as your age, your length of service, your position, and the availability of similar positions or comparable positions within the job market. In exchange for the employer providing you with compensation during the period of unemployment or during some of the period of unemployment, you have a corresponding obligation to be looking for new employment and obtaining it if it's offered to you, unless you have a good reason not to. Essentially, the money that you earn at a new job makes up for the losses that you get from the old job, and so it sort of counteracts one another. And if there's a difference in earnings, then the old employer still owes you the difference, but they don't owe you the full amount. In your situation, however, if you already had the job before your termination, then that would not count as mitigation earnings. So if it's money that you previously earned, or if it's a position that you held prior to the termination, it was pre-existing the termination, so it doesn't count as money that's making up for the losses that you suffered by way of the termination. So what your old employer is responsible for is making sure that you don't have losses that flow from your prior termination or from your prior position. Essentially making sure that the status quo stays the same for a certain period of time, whatever the applicable notice period is under the common law. This is all assuming that you are entitled to more than just your ESA minimums. If you are entitled to common law, they're responsible for making up for whatever losses you may have suffered from the prior, from the loss of your prior position. But you're not suffering losses if you had that job before that position ended. So that money would have been coming whether or not you lost the other position, and therefore, generally speaking, your severance would not be restricted by money that you would have earned anyways. Your severance is only restricted by money that you earn in a new role that you might start thereafter, in sort of replacement of your prior role. I hope that makes sense. Question from Akib on Facebook. I injured myself at work, 2 years of light duties. Doctor said the injury is permanent and now I can't do my pre-injury job. WSIB and the employer had a meeting. They let me go because there's no work that I can do. Can they just terminate me because they don't have any work to accommodate my restrictions? This could be a possibility. This could possibly be a situation wherein you have frustration of contract. Frustration would mean that you are entitled to your ESA minimums because the contract can no longer be performed. So you are permanently disabled and there are no positions that are available to you that would allow you to continue to work for this company. But it's no fault of your own and it's no fault of the company's. It's just a situation that has arisen as a result of your disability. It's possible that that's what will be alleged in this case, in which case you would be entitled to your ESA minimums. In the event that that is not the case, they cannot terminate you during a disability leave, and there is quite a high threshold for accommodation of a disability. So if they have failed to accommodate you, there could be a possibility that you would be entitled to something under the Human Rights Code. There's also the possibility that you would be entitled to severance pay or greater severance pay potentially than what you were offered. It's not clear to me whether or not you were offered any. But if you were offered severance pay, there is the possibility, depending on your contract, that you would be entitled to more. So I would recommend, Akib, on Facebook, that you contact our office and speak to one of our lawyers in order to determine, more facts specifically, which of these two scenarios might apply to you. And in that case, you may be entitled to more severance, or you may be able to allege frustration. It just depends on sort of more fact specific information. Randolph is asking from YouTube is asking a follow-up question. Is it possible to qualify for EI for a job loss if I'm working part-time until I find something else to make up that income? The best person to contact for any EI questions is Service Canada. It's not really something that I typically have to deal with. It's very much government run. However, generally speaking, in order to qualify for EI, you need to have below a certain income threshold before you would even sort of qualify for being considered for those kinds of payments. So I guess really what the question is what are you making at your new job? Please do not share in the comments. I would suggest that you call Service Canada, but it depends on what you're making at the other job. In terms of whether or not you're going to hit the thresholds that EI is going to consider, valid for sort of certifying you for EI. Question from Heather on Facebook. Company introduced a new vaccine policy in October 2021, and you're facing being put on an unpaid leave for not providing your proof of vaccination despite lifting restrictions. What are your rights? Okay, so if you do not provide your employer with vaccination confirmation or an attestation form or whatever kind of confirmation it is that they're asking for, they will treat you as unvaccinated. In the event that you are unvaccinated, depending on your company's policy and the specific terms of that policy, they may put you on an unpaid leave. They may terminate you for cause. It is our position that these unpaid leaves are illegal. It is also our position that it is not cause for termination. However, it does require that you speak to a lawyer in order to determine, based on your specific policy, what option is available to you. If the policy was introduced in October 2021, I would guess that there is some sort of a deadline of some kind along the way. If there isn't, then it's likely a potential constructive dismissal. If there is some sort of a deadline wherein you have to be vaccinated by XX date, it could be the case, or you'll be terminated, whatever, depending on like what the actual clause says. Then it is possible that you could be arguing that it's not cause for termination. It's also possible that they're terminating without cause. Without seeing your policy, it's difficult to say. So what I would say is to call our offices and speak to somebody and get a consultation where they can actually review the vaccine policy that you say was passed in October 2021 more closely and sort of take note of the specific terms of that policy and advise you on that point. Mike Hunt from YouTube says, my company is changing the compensation structure from base plus commission to just salary. This will have the effect of reducing my income by more than 30%. Do I have to accept the change? You never have to sign a new compensation policy. If they're not providing you with some kind of consideration, anything that you would sign would actually be invalid anyways, because offer, acceptance, consideration are the three sort of tenets of contract law. It's it's hard for me to say just based on the fact that it was base plus commission and now it's just salary to understand exactly what is being changed. I'm guessing that they've removed the commission aspect of your contract, but again, it's hard to say. So what I would say, Mike, is to contact our office and speak to one of our lawyers, set up a consultation, and they can then review the two policies and advise you farther. You do not have to accept the change. I would advise that you don't sign anything in the meantime, but I would recommend that you speak to somebody who can sort of look at your specific case more closely. How likely is it that the legislation for to disclose workplace monitoring will be passed and actually enforceable? I can't speak to that, Mark from YouTube. I I don't know what the temperament or temperature at Queen's Park is at this moment. Um, I can't speak to how likely it might be, but uh, I mean, most policies that people have actually do already generally contemplate some kind of monitoring or some kind of sort of internet. I don't want to say monitoring. Some kind of internet policy is generally in an employment contract that's more recent. Um, what that actually allows your employer to do is a question of the actual terms of that contract. I hope this was helpful, and it was lovely to speak with all of you today. I'm Madelena Viksne from Samfiru Tumarkin, and we'll see you again tomorrow at 1. Okay.